Zelda, could you perhaps address the perception that financial intermediaries have that they are required to put in more effort in terms of contract in the financial services space?
Yes, I think from that perspective, it's definitely true that the financial services industry is a very highly regulated industry. If one looks at the various pieces of legislation and the changes that are coming forward, that there is definitely a higher level of duty and obligation on financial advisors. Also, because these advisors are the mouthpiece towards the client or the general public, which gets this information and should get the information in a condensed form, there is naturally a high duty on these advisors to properly explain the products to their clients. And also from that perspective, I think it is critical that advisors also understand that they need to have proper training on products. And in order to make sure that they comply with these legislative and statutory provisions, that they are adequately informed about the products that they sell and that they give the correct advice to clients.
Could you maybe give a brief comment on what constitutes the contract between the advisor and client versus the client and the insurer?
Yes, I think it's a very important distinction, and I think the initial contract or the relationship between the client and the advisor is a contract where the advisor is requested to do certain functions or services, render services. That contract is normally in the form of a mandate where the client will say, as the principal, I'm instructing you as my agent to go source various quotes, to bring me back the best and the most suitable quote, to provide me with advice on that, to assist with the submission of the claims documents or the quotation to the insurance company. And then important from that, it is very important to understand outside of that, once the client submits the quotation and the insurance company accepts that quotation, that a contract comes into place between the insurance company and the client, and that's a separate and distinct legal relationship between the insurance company and the client.
If you could give an advisor one piece of advice to keep their heads clear if they ever had to go to the FAIS ombud, what would it be?
It is critical, in my opinion, that the initial submissions that an advisor makes to the ombud is clearly set out, that you put all your facts on the table, that you make out a case of rebuttal where the claimant has now set up a prima facie case, that the response to that is a proper answer to it, because one needs to understand that the judgments by the ombud has the same effect as a civil judgment, and as such you need to treat it with the same importance than you would with any summons that was issued on an advisor.